Hi, I'm Aslam Moolla and I am a registered attorney, and in today's video we're going to be talking about the principle of hearsay evidence and how it applies especially in cases of disciplinary hearings or in Ccma matters. Now let's start off by looking at what is hearsay evidence. Hearsay evidence is any form of evidence that is given at a disciplinary hearing or at the Ccma case where the person who's giving the evidence was not a party to the proceeding at the time or to the interaction at the time. A good example of hearsay evidence and the effect it has on a Ccma case is the actual case that we have right now. It is an actual Ccma case where two parties, an employer and an employee, went to the Ccma for an unfair dismissal matter, and the commissioner had ruled in favor of the employee because the employer came with hearsay evidence. So let's go into that in a bit more detail and use that as an example to cover the principle of hearsay evidence. The brief facts of this case are that the employee was unfairly dismissed. The employer just sent him an SMS saying to him that he is now off the books. He then referred the case to the Ccma. At the Ccma, the employee presented himself, the commissioner was there, and the employer, which was the owner of the business, decided to send his son to the hearing. He didn't come. At the hearing, after the commissioner listened to the employee and the employer's son, the commissioner said that the employer has relied too much on hearsay evidence. By sending his son, who was not a party to the interaction between the employee and the employer, the son could not testify regarding what happened. He had no personal knowledge of the case, and therefore the commissioner said that to admit whatever the son had to say would actually prejudice the employee, because the principle of law is that both sides must have a fair opportunity, and that means both sides must need evidence that's not only relevant, but the people who are party of that evidence need to come and personally testify. The commissioner also stated that the mere fact that the employer's son came to testify, how would the employee cross-examine the son? Because the son had no part to play in the process. So that is an example of hearsay evidence. Let's see now how it applies to you in your situation, whether you're faced with a disciplinary hearing or a Ccma case. If you're faced with a disciplinary hearing, or a Ccma case for that matter, the company can send whoever it wants to as a representative for the company. However, the witnesses who are party to the incident itself, they must come and testify at the hearing or the Ccma. The witnesses who have personal knowledge of the case. In other words, there is a difference between a representative and a witness. And in that example case that we went through now, the owner got confused between the two. He was allowed to send his son as a representative, but he himself should have come to testify because he was a witness to the case. And that is the key principle. So in summary, if you have a situation in the hearing or at the Ccma where someone who's come to testify and they've got no personal knowledge of the case, they were not a witness, you can object to that and say that is hearsay evidence. It is your right which is entrenched in our law. If you need help in your situation, whether that's compiling your evidence, assessing the strengths of your case, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.